On the afternoon of March 5th, 2024, Penny McCarthy was doing yard work outside her home in Phoenix, Arizona. It was an ordinary Tuesday, the kind that doesn't end up in a court filing. She was 66 years old, a grandmother, a woman with no criminal record beyond a single traffic infraction somewhere in her past. She had lived in that house long enough to know her neighbors, long enough to have a routine. Long enough that a Tuesday afternoon spent working in her own front yard wasn't something she thought twice about. Then, 3 unmarked vehicles turned into her driveway. There was no siren, no announcement over a loudspeaker, just doors opening and armed men stepping out with rifles already raised. They ordered her to put her hands up. She did, immediately, without hesitation, the way anyone would when the first thing they see is a weapon pointed in their direction. Then she asked the only question that made any sense to her in that moment. "For me?" They confirmed it. There was a warrant, they told her, and it was for her. What Penny McCarthy did in the minutes that followed is the reason this case exists on paper today, sitting in a federal courthouse under her name, working its way through litigation. She didn't run. She didn't fight. According to her own account and body camera footage later obtained by the ABC affiliate ABC 15, she asked who they believed she was. She asked whether the men in front of her could confirm they were actually police. Those aren't unreasonable questions to ask a group of strangers who have just pulled unmarked cars into your driveway and pointed guns at you. But the footage shows those questions went unanswered. Instead, McCarthy has said, she was told that if she turned her head to look at the officers positioned behind her, she would be struck or tased. She was not shown a warrant. She was not told whose name was on it. Not before she was handcuffed, and not for some time after. From the outside, there was nothing to distinguish what was happening on that street from the arrest of an actual fugitive. The vehicles were unmarked. The officers were armed and moving with the urgency of a team that believed it had found exactly who it came for. Nothing about the scene signaled that a records error was in progress. That's part of what makes a case like this one so difficult to catch before it happens. From the moment those doors opened, everyone present, including McCarthy herself, had every reason to believe this was a legitimate, correctly targeted arrest of a wanted fugitive. It would take a federal judge, a fingerprint lab, and more than a month to establish otherwise. This is the story of what happened when that warrant turned out to belong to someone else entirely, and of the 24 hours, the 3 strip searches, and the more than a year of investigation and litigation that followed, a single case of mistaken identity. The warrant the U.S. Marshals Service was executing that day was 25 years old. It had been issued in 1999 out of Oklahoma, tied to a nonviolent parole violation. The woman named on it, Carol Ann Rozak, had allegedly failed to report to a probation officer after being released from federal custody. That was the offense at the center of the warrant. Not violence, not an ongoing threat, but a missed check-in with a probation office a quarter-century earlier. By March of 2024, Rozak would have been roughly 70 years old. Penny McCarthy, 66 at the time, had no history with Rozak. No shared address, no shared case number, nothing connecting the 2 women beyond whatever surface-level resemblance existed somewhere in an old file. According to the Institute for Justice, the nonprofit legal organization that would later take on her case, the identification that sent armed marshals to her driveway rested on limited materials, old records and open-source documents pieced together from a distance, with nothing resembling a fingerprint check or DNA comparison behind it. Somewhere in that process, a decision was made that the resemblance was close enough to act on. Nobody checked further before the vehicles were dispatched. Warrants like the one attached to Rozak's name don't expire on their own. Absent in the federal system, a decades-old parole violation warrant can sit in a database indefinitely, waiting to be matched against a name, an address, a description, waiting for someone, somewhere, to run a search that pulls it back up. 25 years is long enough for a person's life to change entirely. It's long enough for addresses to turn over, for descriptions to age, for two entirely unrelated women born decades apart in different states to end up close enough on paper that a record search treats them as plausible matches. The system that produced that resemblance wasn't personal. Nobody at the Marshals Service had any reason to specifically target Penny McCarthy. But an impersonal error, once it's acted on with rifles drawn, doesn't feel impersonal to the person standing in the driveway. McCarthy was handcuffed in her own front yard, on a residential street in the middle of the afternoon. She was placed in a vehicle and driven more than an hour away, to a federal detention facility outside the immediate Phoenix area. Over the next roughly 24 hours, she was strip-searched 3 separate times. She was held overnight in a holding cell, without the charge against her ever having been confirmed against anything more concrete than an old paper trail. The next morning, she was brought before a federal magistrate, booked, processed, and presented to the court not as Penny McCarthy, but as the fugitive the Marshals Service believed her to be. What happened in that courtroom is, in some ways, the hinge the entire case turns on. The magistrate judge looked at the file in front of him and did something that, on paper, seems almost obvious, but rarely happens quickly enough in cases like this one. He asked Assistant U.S. Attorney Kevin Rapp directly, why had this woman been arrested as Ms. Rozak? According to the court record, the prosecutor's answer traced back to the same limited materials the Institute for Justice would later describe publicly. Old records, open-source documents, nothing that amounted to a scientific confirmation of identity. Not a fingerprint match, not DNA. A judgment call made somewhere up the chain of the investigation, one that had already resulted in a 66-year-old woman with no relevant criminal history spending a night in federal custody, strip-searched 3 times, over an hour from her own home. The judge did not dismiss the matter outright that day. Instead, McCarthy was released under weekly check-in conditions, pending something called an identity hearing, a formal federal proceeding in which she would have been required to affirmatively prove that she was not Carol Ann Rozak. Not the government proving she was, her proving she wasn't. Before that hearing could take place, a full fingerprint and DNA analysis was ordered. It confirmed exactly what McCarthy had been telling anyone who would listen from the moment those vehicles pulled into her driveway. There was no match. There never had been. ABC 15 in Phoenix ran its first investigative report on McCarthy's case in the days following her release, digging into the arrest, the warrant, and the gap between the two. The next day, April 8, 2024, the proceedings against her were formally dismissed. Not long after, the U.S. Marshals Service publicly acknowledged that the fingerprints did not match, a fact ABC 15 confirmed and reported in a follow-up piece specifically built around that admission. But a dismissal, however necessary, doesn't undo the 24 hours that came before it. McCarthy told reporters that she now feared being outside alone. She said she had stopped walking her own dog without someone else present, a small, quiet detail, but one that says something about what changed in her daily life after that Tuesday afternoon. In the months that followed the dismissal, she sold her house. She left Arizona entirely. A woman with no criminal history, who had been comfortable enough in her own front yard to be doing routine outdoor work on an ordinary weekday, no longer felt safe living there. Not because of anything she had done, but because of a mistake made somewhere in a record system that hadn't been updated or verified in 25 years. She described herself to ABC 15 in a phrase that would go on to be repeated across nearly every outlet that later picked up her story. A senior citizen who got picked up at gunpoint in her own front yard. It's not a dramatic phrase, it's a description, and it's accurate. There's a particular kind of damage in a case like this that doesn't show up in a docket entry. A dismissal restores a person's legal status. The charges are gone. The record is clear.
The identity hearing never has to happen. What it doesn't restore is a sense of safety in a place that used to feel entirely ordinary. McCarthy wasn't arrested in a parking lot or during a traffic stop or anywhere that carries even a passing association with law enforcement encounters. She was arrested doing yard work on her own property in the middle of an unremarkable afternoon, the kind of setting most people spend their whole lives treating as the safest place they know. Selling that house wasn't a legal remedy. It didn't appear in any settlement negotiation or court order. It was simply what she decided she needed to do once the yard itself had become something she couldn't stand in anymore, without thinking about what had happened there. The case did not stay contained to a single Phoenix news cycle. In November 2024, 8 months after the arrest, US Representatives Jim Jordan and Andy Biggs sent a formal letter to the Department of Justice's Office of Inspector General demanding an investigation into how the Marshals Service had conducted the arrest and identified their target. Their letter cited what they characterized as carelessness and excessive force on the part of the agency. That request led to an active OIG investigation, one that, as of the most recent reporting available, has not produced a public final report. In late December 2024, investigators from the Inspector General's office sat down with McCarthy directly to hear her account of what had happened. Then, on June 9, 2025, more than 15 months after 3 unmarked vehicles pulled into her driveway, Penny McCarthy filed a federal lawsuit against the United States government in the U.S. District Court for Arizona. She was represented by the Institute for Justice, with senior attorney Paul Avalar leading the case on her behalf. The complaint invoked the Federal Tort Claims Act, the Fourth Amendment, and Arizona state law, alleging false imprisonment, malicious prosecution, and unreasonable search and seizure. In an opinion piece published by The Hill, Avalar described his client in blunt, unadorned terms. A wrongly arrested grandmother now taking on the United States Marshals Service. It isn't rhetorical flourish so much as an accurate description of the imbalance sitting at the center of this case. A federal law enforcement agency, backed by the full resources of the US government, on one side. On the other, a retired woman whose entire connection to any of this was an old-file resemblance nobody bothered to verify before deciding it was worth pointing rifles at her. It's worth pausing here on what the Fourth Amendment actually requires, not as advice, but as the legal framework this case is now being argued inside of. The Fourth Amendment protects against unreasonable searches and seizures, and an arrest is, constitutionally speaking, a seizure of a person. That seizure is generally required to rest on probable cause, a real, particularized basis for believing that this specific individual committed this specific offense. Old records and open-source documents, absent something as basic as a fingerprint comparison, sit uneasily against that standard. McCarthy's lawsuit doesn't simply argue that an error occurred. It argues that the error was avoidable, that the tools capable of confirming or ruling out her identity existed well before marshals ever pulled into her driveway and simply weren't used until after she had already spent a night in a federal holding cell. That argument is now sitting in front of a federal judge in Arizona, unresolved. The Marshals Service has publicly acknowledged the fingerprint mismatch, but acknowledging that a mistake occurred and being held legally liable for the consequences of that mistake are two separate processes, decided under two separate standards, and there is no guarantee the second follows automatically from the first. Federal Tort Claims Act cases against the government carry their own procedural hurdles, and a Fourth Amendment claim of this kind will likely turn on exactly how reasonable a court finds an identification built entirely on decades-old paperwork. There's also the matter of who exactly can be held responsible. Suing federal agents directly for constitutional violations is its own difficult path, one that has narrowed considerably over the past decade of federal case law, which is part of why McCarthy's suit leans on the Federal Tort Claims Act, a mechanism
that allows certain claims against the United States government itself rather than against the individual marshals who carried out the arrest. That distinction matters. It's the difference between a case that lives or dies on the actions of a few individual officers and one that puts the underlying process, the records system, the verification standard, the decision to act without a fingerprint check, squarely in front of a court. Whether a judge agrees that process fell short of what the Constitution requires is the question this case is actually built to answer. There's one detail in the record worth naming carefully because it hasn't been independently confirmed, and a documentary account of this case should be honest about the edges of what's actually known. One earlier ABC 15 article included a quote referencing a woman named Penny Burns in connection with the identity mix-up, suggesting Rozak may have used, or at some point crossed paths with, that name in connection with the underlying Oklahoma matter. Whether that's a maiden name, a piece of reporting shorthand, or a separate mismatched detail buried somewhere in the original Oklahoma court filing isn't clear from anything publicly available. It's included here not because it changes the core facts of the case, but because leaving it out entirely would understate just how tangled and imperfect these decades-old identification files can become, and because omitting an unresolved thread isn't the same as it not existing. That same standard of honesty applies to the case as a whole. As of the most recent reporting, both the DOJ Inspector General's investigation and McCarthy's federal lawsuit remain open. No Inspector General report has been released publicly. No judgment has been entered in the civil case. This isn't a story with a tidy, closed ending, because it hasn't reached one yet. It's a story about the space between an arrest and its resolution, and about how long that space can stretch when the person on the wrong end of it is fighting a badly verified 25-year-old warrant rather than an actual crime she committed. What makes McCarthy's case resonate the way it has isn't only the fact that a mistake was made. Mistaken identity arrests are not, unfortunately, unheard of in federal law enforcement. Agencies handle thousands of active and cold warrants, and errors happen. What stands out here is the sequence, the order in which things did and didn't happen, and how long it took for the correction to catch up with the arrest. She was not shown the warrant before she was restrained. She was not told whose name was on it, not in that first exchange in her driveway. The identification that justified pointing weapons at a woman doing yard work in front of her own home rested on decades-old paperwork, not on the kind of biometric confirmation that exists specifically to prevent exactly this outcome. And the confirmation that arguably should have come first, the fingerprint and DNA analysis that ultimately cleared her, arrived only after she had already been strip-searched 3 times, transported over an hour from home, and held overnight. The magistrate judge's question in that first hearing, why was this woman arrested as Ms. Rozak, is, in a sense, the entire case compressed into a single sentence. It's the question a court asked out loud, on the record, within roughly 24 hours of the arrest itself. It would take more than a year after that moment, a congressional letter, an inspector general interview, and a formal federal lawsuit, for that same question to move from a passing aside in a Phoenix courtroom into a fully litigated legal claim against the United States government. McCarthy is not the plaintiff in a case built around an abstract policy argument or a principle she set out to establish. She's a woman who eventually sold the house she was standing in front of when this began because she no longer felt safe in the yard where it happened. That particular detail doesn't appear anywhere in the legal filings as a cause of action. No court can award damages specifically for undoing it. But it's the part of this case that doesn't end when the lawsuit does, regardless of which way it's eventually decided. The Institute for Justice has continued to track the case publicly through its own case page and video materials. ABC 15's investigative unit, meanwhile, has followed the story across at least 6 separate reports since the arrest, from the first piece that ran the day before charges were dismissed, through the release of body camera footage, through the Marshals Service's public acknowledgement of the mismatched fingerprints, up to the congressional letter demanding a formal review. Each report added a detail the previous one didn't have. None of them, so far, has been able to report a final outcome, because there isn't one yet to report. That's where the case stands as of now, an open federal lawsuit moving through the U.S. District Court for Arizona, an unresolved Inspector General investigation with no public report, and a woman who no longer lives in the state where 3 unmarked vehicles once pulled into her driveway over a warrant that was never hers to begin with. It's worth noting what this case is not. It is not, at this stage, a finding of wrongdoing by any individual officer. The lawsuit names the United States government as defendant, not the marshals who carried out the arrest, and nothing in the public record establishes that any one person acted with anything other than a genuine, if mistaken, belief that they had the right woman in front of them. That distinction is part of why McCarthy's case has drawn attention from lawmakers across the political spectrum, rather than becoming a partisan flashpoint. Jim Jordan and Andy Biggs, the 2 representatives who sent the letter demanding an Inspector General review, aren't typically aligned with civil rights litigation groups like the Institute for Justice on much else. Here, the underlying facts did the work. A fingerprint check that should have happened before an arrest happened, only after one. If there's a final report from the Inspector General or a ruling in McCarthy versus the United States, this channel will come back to it. Cases like this one rarely resolve quickly, and they rarely resolve cleanly, but they do resolve on the public record, in filings and court orders anyone can go read for themselves, which is more than can be said for whatever internal process first matched a 66-year-old grandmother to a 25-year-old warrant that belonged to someone else. If you followed a case like this one before, where the paperwork took far longer to catch up than the arrest itself did, let us know where you're watching from in the comments below. It's always worth seeing how far these stories actually travel and how many people they turn out to have reached. I'm Marcus Whitfield. Thank you for listening to the Fourth Amendment Files.